All right, it is noon, and I'd like to thank everybody for joining us. We still have some that are joining us in as we speak on things. Thank you for joining us. I am Jacqueline Jones Doyle with the Tarrant County AgriLife Extension. With us today is Tiffany Dowell-Lashmet, who is our speaker today. And before we get started, just a few little logistic aspects of things. We do ask that everybody mutes your microphone. And if you would, go ahead and close out your video on things. It just helps with the bandwidth and kind of keeps things moving on things. Throughout the presentation, if you've got any questions, please stick those in the chat box and we will get those referred to Tiffany as we go. She is allowing some time at the end of the presentation today for questions. Again, thank you for joining us. And Tiffany, I will turn it over to you.
Okay, sounds great, Jacqueline. Thank you so much for the opportunity to do this program today. Like Jacqueline said, my name is Tiffany Dowell-Lashmet. I'm the Extension Agricultural Law Specialist for Texas A&M. And so that means I basically travel the state of Texas doing educational outreach to rural landowners and ag producers. And so my work covers kind of a variety of topics. And today I'm talking kind of the basics of estate planning being one of those. And so I'm really excited to be here. I wanted to start off, and I do this anytime I do a Women in Ag type program and mention, I always say this is why I am here. This is my grandma, and she was a true woman in ag. And so that's really where I got a lot of my interest in ag in general, but certainly in this topic. And so I grew up on my family's farm and ranch in New Mexico. My grandma and grandpa started that farm in the 50s, having both been involved in agriculture prior to that. And then my grandmother was in her 40s, and she had two teenage sons when my grandpa dropped dead of a heart attack one day. And so it was up to her to continue on our family farm. And she had, a farm to run, a teaching job in town, and two sons to raise. And everybody told her she should sell that farm and just move to town. She was stubborn. She didn't listen. And I grew up on that farm. My kids are now going to be the fourth generation there. And so anytime I get the opportunity to do a Women in Ag program, I always try to say yes, if my schedule will allow it, in part to honor my grandma and all that means to our family. So we'll start with that. And then I'll also give you a little disclaimer. This basically says I'm a lawyer. I am not your lawyer. So like Jacqueline said, we're certainly glad to answer your questions today. As we go along, you can put those in the chat box and we'll take some questions as we go. At the end, we'll have an opportunity where you can either type your questions in the chat or we'll let you unmute your mic and you can ask them verbally if you prefer to do that. So glad to take your questions. I cannot give you any specific legal advice. If you need that type of advice, you'll want to talk to an attorney who's licensed in your jurisdiction. One offer I will make on that is if you need help finding someone who does estate planning with some agricultural knowledge, feel free to reach out to me. I'll be glad to help get you in touch with somebody here in Texas that can hopefully help you on that topic. All right. So, a couple of resources from me. Let's see if I can. Okay. A couple of resources from me. The first one is I've got a blog. So it's called the Texas Agriculture Law blog. So if you're interested in agricultural law, not just in Texas, but around the country, we cover kind of a wide range of issues there. And so when you go to this website, what you'll find is a pop-up box. I know those are annoying. I'm sorry. But if you'll put your email address in there, what happens is you get added to my mailing list. And every time I do a new post, which happens once or twice a week, it'll come straight to your inbox. And so you can read it there. I also have a tab. You can't see it very well on there, but I've got a tab on that website called Published Materials. And every document that I have published, every fact sheet, every handbook, any sort of video I've done, those are all going to be available there for free to download. So, we've got tons of information there. So check that out if it's something that might be of interest to you. Okay, I've also got a podcast. And so, again, if you're interested in agricultural law and you're a podcast listener, we're on all your apps. Just look for Ag Law in the Fields. If you're not a podcast listener, or maybe you don't even know what a podcast is, that's okay. You can just go to that website. It's called aglaw.libsyn.com. What you'll find when you get there is a list of 170 different interviews I've done with some of the best lawyers in the country. You can just pick the topic you want to listen to, push play, and you'll get an audio only, so no video, an audio only file to listen to. So, like I say, we've done a ton of different topics, lots of information there related to estate planning, lots of information there on, things like fence law, liability. Our most recent episode was on environmental law. We've got one coming out next week dealing with renewable energy leases and kind of the top tips for negotiating those. Just in time for tax season, we're going to have one on the top 10 things that farmers and ranchers should know about taxes. So really interesting information. If you want to learn more, you can check that out as well. So with that, we're going to jump into our conversation. One more kind of caveat from me. What we're going to focus on today is Texas law. A lot of this would apply no matter what state you're in. I know we've got some folks from out of state. I think we've got some Oklahoma attendees and some Louisiana folks as well. Where something is specifically different, I'm going to try to flag that for you. Okay, so unless I flag it, it should be generally applicable kind of around the country. Okay, so with that, let's kick things off. The first thing I want to talk about is what happens if you die and you have nothing in place from an estate planning perspective? And I wish this wasn't a question that we needed to ask, but the statistics tell us we better look at this. And that's because the statistics say that only about half of Americans have a will or other form of an estate plan. Right, and that's problematic because there's not a lot of data I'm completely comfortable with, but I'm confident 100% of Americans are going to die at some point, right? And need that estate plan. So half of Americans have it. If we look at farm, ranch, and agribusiness owners, I wish I could say we're better, but we're worse. And it's only about 1/3 of farm, ranch, and agribusiness owners that have some sort of estate plan in place. And so I would beg of you, if you don't take anything else away from today, you need to, at the very least, have a basic will in place. We'll talk about the documents you need later, but the reason for that is because you don't want to land in the process that comes about if you die with nothing in place. And that process, the way that works, if you die without a will, or some other plan to take care of your assets, like a trust or, transfer on death designations, things like that. But if you die without something in place, the government's going to determine where your assets go. And that happens through something called the intestacy process. And so the way that it works is all 50 states have what's called an intestacy statute. And it's basically like a formula that tells you where your assets go if you die without a will or other estate plan. So as you can imagine, this causes some problems, right? The likelihood of disputes among heirs can really increase with intestacy statutes. And that's because there's no family that's one size fits all, but the statutes are, right, a one-size-fits-all formula. And so a lot of times what the statute does with your assets is never something you would have done voluntarily. It never would have been your plan, but you lose all control if you die without that plan, because then these statutes are what's going to govern. Okay. The other thing that can be really problematic with the statutes is that the probate process will take longer and will cost more money. So I have a lot of guys that I talk to at meetings, right? Farmers that are like, oh, we don't want to pay a lawyer. And so I always try to get them with this. Listen to me. If you want to save money, get a will, because it's going to be cheaper to hire that lawyer to do that will than it is going to be for your estate and your heirs to have to deal with the probate process and the whole intestacy portion of that if you don't take care of it. And what happens if someone dies without a will, before you can ever get to actually probating anything, you have to go through this entire rigmarole ahead of that to figure out who their heirs are. Do they have any children? All sorts of information that has to be done through the court. It's going to take attorneys. They're going to appoint like an attorney ad litem for the heirs. It's just a mess, and it really makes things more complicated and more expensive. So even if you don't want to spend a ton of money and get like a really fancy estate plan, if you just had a simple will, that kicks you out of having to worry about the intestacy process. Okay. So, and then all this is true in every state. All right. Let's look next at some sample intestacy results in Texas. Now, the statutes are all different state by state, so the results of this would not be the same in other places. All right. But in Texas, let's assume we have a husband who dies without a will. Where does his property go? And a lot of times people will say, well, it goes to the wife. That's simple. If it was that simple, I wouldn't be here harping on this. Okay. So let's look, if you look at the box on the left, if the husband was married when he died and they had no children, the intestacy statute says that the wife gets all of the personal property and half of the real property. Real property is the land, right? The other half of the real property goes to the husband's parents. So what you can end up here with very easily is your wife owning the land in halfers with her mother-in-law. How many of y'all think men would draft that up as a plan that they think is going to be successful, right? So there's one example. If we look at the box on the right, let's say that the husband is married with children. I have an asterisk here. Let's assume these are all children of the marriage. Okay, so no stepkids, no half siblings, anything like that. Husband is married with children. The statutes say that his wife gets half of the personal community property and the children get the other half. For separate property, if it's personal property, the wife gets a third and the children get 2/3. And for real property, the wife gets a third as a life estate and 2/3 goes to the children. Here's what I'll tell you. I want no part of owning anything that involves that many fractions, right? You can imagine what a headache this is going to be at the bank, at the property tax office, all those places, okay? So again, you never want to rely on the intestacy statutes. There are easy things you can do to get yourself out of that. We'll talk about drafting a will in just a little bit. So if we take one thing away today, I want it to be do not die intestate, okay? I've got a friend that's a lawyer in Central Texas, and he always says, die with a will. It's easier on everyone that way. So that's another way to put it, okay? So if I've convinced you now that you need to have a plan, right? Let's talk about what the steps are to that successful transition. And I've adopted these from my friend Shannon Farrell, who essentially has my job at Oklahoma State. And we've got a 5-step plan to a successful transition of your farm and ranch to the next generation. Okay, so let's walk through each one of these. And I'm going to just tell you 5 is super misleading because there's lots of subparts under each of these. Okay, we're going to start off with creating a flight plan. All right, what is a flight plan? So I've been teaching this class for several years, and I always struggled with what to call this idea. The idea is you need to have something like a box or a folder or somewhere that you put all of your important documents, okay? And I mean, I was calling it a death folder, but geez, it's hard to get people motivated around that, right? And I was speaking out in San Angelo, and a little old lady came up to me and she said, honey, don't call it a death folder, call it a flight plan. You know, like the song, I'll fly away, oh, flight plan. I loved it. I stole it. I've used it ever since, okay? So the flight plan is just going to be somewhere that you're going to gather up all of your important documents and information where if something happens to you, whether you're incapacitated, whether you pass away, whatever it is, somebody can walk into your house, get this information, and be ready to go and do what needs done. Okay, so what do we include in the flight plan? I've got a whole list of things for you. The good news is this step is free. You don't need a lawyer to do this. You can do it for free. The bad news is it's kind of a pain in the rear. All right. So let's walk through what you need. The first thing you need is estate planning documents. If you currently have any sort of documents like a will or powers of attorney or trust documents, get those in the flight plan. Because when somebody dies, the very first thing from a legal standpoint you've got to figure out is, did they have a will or not, right? You don't want people having to like dig through the boxes under the bed, or, you know, if they're like my dad, we'd be digging through the glove box in the feed truck to try to find these documents, right? So get them all in one place. Information about any sort of retirement plans, things like an IRA, 401k, pensions, anything like that. So I think about my own family. You know, my dad has worked for the same company for 35 years. I know that he has a retirement account. I have no idea where that's held or how to get any information about it. So, you know, if you just had some basic information, right? Like I have an IRA at this bank, here's who to contact, maybe here's the account number, right? That kind of information just helps people from having to track all that down. They know where to start. Copies of life insurance policies. If you've ever dealt with life insurance, right? They don't call you, you have to contact them. So make sure you've got copies of any sort of life insurance. Same with other types of insurance policies. I know there's cancer insurance that some people have, long-term care insurance. If you've got any of that, those are great tools, but people have to know how to, again, contact them. So include that information in your flight plan. Bank account information, hugely important here, right? Someone needs to know where all of your accounts are and how to access them. So there's a couple things you could do. You could make a list. What my parents did is they went and they took the front page off of their bank statements one month and just stuck the front page in the flight plan. Because now I have the bank, I have the account number, the information I would need to go track this down. Okay. While we're on bank accounts, I want to talk about this for a second. You need to look at your bank accounts and make sure you know how those are held. What I mean by that is, how is that bank account set up and what will happen if one of the owners dies? So for example, when you go and open a checking account, you've got to check a box. Used to, it was on like the card, the paper card that you used. It's probably online now. But on the paper card, you would check a box, right? That it's a joint account or it's a joint account with right of survivorship, right? Another option might be it's a transfer on death account, okay? Depending on which box you check governs what happens when somebody dies. So if you've got a joint account, when one of those owners dies, it does not automatically pass to the other owner, right? The deceased person's portion of that would pass through their estate. If you had an account that was joint tenants with rights of survivorship, then the remainder of that account does pass to the other owner. It doesn't go through the estate. So which little box you checked when you opened your account can have a profound impact from an estate planning standpoint. So I would encourage you, take a look at those, make sure you know how you have them set up. Okay, safety deposit box information, really important. If you have a safety deposit box, make sure someone knows where it is and make sure you know who has access. This is particularly important if you're going to put the flight plan in the safety deposit box, right? Someone besides you needs to be able to get in there. Another good idea to have is just some basic information about your debts and pay schedules for your bills. And this comes into play from an estate planning perspective, but also just like a life planning perspective. So I don't know how it works at your house. In my house, I'm the one who handles paying all of the bills. I have a job with a computer. So on my lunch break, I can do the banking, right? My husband's out in the field somewhere. And so if I got hit in the head today and was unconscious for a month, my husband has no idea what bills we have, when they're due, how much they are, how to pay them, right? None of that. And so I have made a little sheet of paper and it lists out, right? Like on the first of the month, here's what I pay, right? The land payment, the phone bill, the electricity bill, whatever. And then generally how much they cost. Okay. I also have the information about our bank online bill pay in there. So again, something helpful to have if somebody had to step in and take over for you. Copies of health insurance policies. Again, if somebody's in the hospital and can't tell you where this is, it'd be useful to know. Burial plot location and funeral instructions. If that's something that's important to you, if that's something you've done some pre-planning with, make sure that's included. Okay. We're going to keep going here. Email and computer passwords. Okay, this is one that it's super easy to overlook, but we do so much of our life now online. If someone dies, you likely are going to need to get into their email. You may need to get onto their laptop. You may need the passcode to get into their cell phone, right? All of those things, any accounts they have. If someone's managing social media for your farm, or they are the ones who manage the website or the banking, whatever it is, make sure all of those passwords are somewhere that you can get access to. These are just lots of, the next two are lots of legal documents that you probably have somewhere around the house. Deeds, titles, registrations, leases, royalty documents, water permits, surveys. So, like when you buy property, you go to closing, they give you one of those big long folders that I am guilty of just sticking in the back of the closet somewhere. All those documents, that's legal documents that are important, put them in the flight plan, right? I mean, somebody can go find the deed and the deed records, but you could save them a trip to the courthouse, okay? Same with birth certificates, marriage licenses, social security cards, military discharge papers, death certificates. It's shocking how many times when someone dies, you need that death certificate. So another good thing to keep in a flight plan if someone's died in the recent past. The next one is a list of your property, and that's personal property, farm or business assets, right? Things like structures, equipment, vehicles, land, livestock. Couple of reasons for this, okay? The first is just somebody needs to know what you owned. I think back, I had a good friend who lost a brother. The brother was in his 30s. He died in a farm-related accident. He was single at the time, and he died. And months later, the family figured out that he had partnered on a bunch of cows with someone out of state because of something they saw on Twitter. They didn't know, right? So have a list of that, again, where somebody knows where all of your investments are, where your assets are, things like that. Okay. Another reason this is important, here in a few minutes, we're going to talk about the estate tax. And one thing you're going to have to know for the estate tax is whether or not, is what is the fair market value of your estate. Okay. To do that, you've got to have kind of an idea of what your assets are, right? So, and I'm not saying you got to go through your house and list 7 hand towels or whatever. I'm not saying that. But if you've got things that are different, right? So if I have a normal house, I can guess the value of the contents of the house, right? There are actuarial tables for insurance that'll do that. But what if I have a really extensive art collection or a really extensive firearm collection? Right? Or what if, I need assets. That's not something most people have. Livestock are not an asset that the average person has. So figuring out what you have and then the estimated fair market value is important, again, to analyze your estate tax liability. Copies of crop insurance policies and FSA contracts. Okay. Listen, guys, when somebody dies, and this happened to my own family, my dad tells a story about this, but when somebody dies, a lot of times there's a real reckoning that happens at the FSA office. And I think probably that's twofold, right? One thing is a lot of times it's one person in the family that deals with the FSA. So in our family, it was my grandpa. My grandpa did everything at the FSA. My grandma didn't know where the office even was, right? That wasn't what she managed. And so my grandpa dies and she has to go into the FSA office. And the other thing I think is problematic there is they don't speak in English, right? They speak in acronyms. They throw all sorts of stuff at you. ARC, PLC, EQUIP, CRP, ELP, this whole alphabet soup. And if you don't know what any of that means, it's very overwhelming, right? So I really encourage people, make sure that at least if somebody has to go to the FSA or the NRCS office, set them up to not feel like a complete idiot, right? We have a list of all of our farm numbers. Where if somebody has to walk into the FSA, at the very least, they know what our farm numbers are. They can look up the information. They've got a place to start. All right. A list of your business relationships. This is particularly important if you've got heirs that don't live on the farm or heirs that aren't involved in the operation. So who's your lawyer, your accountant, your banker, insurance agents, investment managers, livestock buyers or livestock haulers, right? Just have a list of who you do business with, because again, it'll save somebody having to try to go track all that down. Okay, so that's step one, which is the flight plan. I'm going to pause just for a second. Jacqueline, do we have any questions so far on the flight plan or anything else?
There's nothing in the chat box as of right now, Tiffany.
Okay, perfect. Well, remember, if you guys have questions, feel free to pop them in there. Okay, and we will continue on then to step number 2. Oh, actually, one more thing on the flight plan, the gun safe lesson. Okay, I've given this presentation for 10 years now, right? And somebody came up to me at a program and he said, hey, I thought of something you didn't include, the combination to the gun safe. And I was like, yeah, you're right. I need to have something on there about where keys and locks and combinations and passcodes and things like that. And then I thought about my own life. Guess where my own flight plan is? In the gun safe. Guess who has access to that gun safe? Me, my husband. The vast majority of our flight plan right now deals with who is supposed to take care of our minor children if we both die in some sort of tragic accident, right? It does me no good to have all that done and then lock it away in the gun safe that nobody can get to. So just a reminder, do include combinations and codes and things like that, but also make sure somebody else knows where your flight plan is and can get to it. Okay, so that's the gun safe lesson. Okay, step number 2 is going to be determining your goals. And this is where you really are going to have to do some thinking, right? You're going to have to think about, what are my goals, right? As we do an estate plan, one of the first things a lawyer should ask you is, what is your number one objective, right? What do you want to have happen with this plan? We'll look in just a second at some common goals that I see. Okay, one way to get the ball rolling on figuring out what your goal is and kind of what your plan might be is to have a family meeting. All right, listen, I can think of nothing that most farmers and ranchers want more than to get to sit down around a table and talk about their feelings, right, with their family. Okay, I grew up in that type of family. I understand the dynamics at play here. All right. I really do think having a family meeting is one of the most important things you can do to help you get your head around what this plan needs to look like. So I say here, I don't recommend the Uncle Fred approach. Everybody has someone like Uncle Fred who says things like, well, I'm not going to worry about it. I'm not making a will. I'll just let them fight over it when I'm gone. That's a terrible way to plan for the future, right? I understand you will be gone, but it will be a fight, right? It's going to be a mess. The intestacy statutes come into play, all these things. That's just no way to run a business, right? And we need to keep in mind that your family farm ranch operation is a business. So, I don't know, Google would never, their estate plan would never be, I'll die, let them fight over it, right? No. The other thing that I see sometimes and this is a mom thing, so heads up to the moms in the crowd, is the mom will say something like, if we leave it to them together, they'll have to learn to work it out. Newsflash, they're not going to work it out, right? You, typically speaking, mom is the one who kind of holds everything together, keeps the peace, everybody behaves for mom. Mom dies, it's not going to get better, particularly when you throw something like managing a farm or ranch at them and think it's going to work out. So I don't think either of those are the best approach, okay? I think instead it's worth having a family meeting, right? Let's have a sit down and let's talk about things. I think it's a good idea to get everybody sat down that's interested, right? Parents, kids, in-laws, right? Spouses of your kids, grandkids maybe need to be involved, aunts and uncles, whoever might be involved in this, get them all together. Now, let me be clear. I'm not saying your kids need to tell you what to do. I'm not saying that at all. What I am saying is I think getting some information from your kids about what they're thinking or what they might suggest or want, that's just good information to have. So talk about things like, what are their interests? Do they have any interest in coming back to the farm? Do they have any interest in maybe owning the farm as an absentee landowner? What are their goals? What is their willingness or their ability to participate in this operation? Do they have concerns about doing that? Does their spouse want them to do that? Right? Lots of farm families, it's a big issue where maybe the farm kid wants to come back home and their spouse doesn't. The kids need to be talking about that too as part of this whole process, right? Think about the best time to do this. Probably it's not Christmas Day, right? I get the appeal of that. We're all in one place. We're here together. Let's just knock it out. Talk about a way to ruin the holiday. Okay. So I would not recommend Christmas Day. I would tell you that this may be ongoing. And that's been my own family story. We had our initial sit-down meeting probably 2 years ago. We come talk through some stuff. Didn't really finalize anything, but we had some things to think about. This comes up periodically, and we talk through things, like, well, what if we did X, Y, or Z? Or what are you thinking about this particular, place? Or, well, are you going to invest in this now? Because who's going to get it when mom and dad are gone? So it has really opened up the conversation and let everybody really think through it and keep talking about it, which I actually think has been really beneficial. I will tell you, especially if you've got a particularly complex estate, like really, complex or substantial assets, or you've got a really complex family dynamic, there are people that can help. If you want professional help with this meeting, there are family communication specialists, there are mediators that you could potentially look at bringing in. Okay, and so once you kind of gather up this information, you need to really think about what's your most important goal. I told you I'd share some common goals that we see. We did a survey about a year ago, and we asked people, and the number one goal of most people involved in agriculture from an estate planning perspective was to keep the land in the family. Okay, and so how you structure a plan when that is your number one goal, right? Keep the land in the family, is completely different than how you would structure a plan if your number one goal is to minimize taxes when the land is sold, right? That's two completely different legal setups. And so that's why you've got to know your goals. Divide everything equally between the kids. That is sometimes a goal for folks, right? We are going to divide this right down the middle, no matter what, to the cow, right? 50-50 between the kids. For some people, the goal is to keep the land in farming. It doesn't have to be the family that's doing the farming. Maybe it doesn't even have to be the family that owns the land, but they want to make sure that land is always a farm, a ranch, open space, whatever it might be. Keep the greedy daughter-in-law's hands off the place. I hear that from time to time, okay? Make sure our kids are still speaking at the end of this. If you ask my mom, that would be her number one goal. She doesn't really care who gets what. She wants to make sure that the family is still speaking to each other and we don't end up in some sort of fight over the operation. Here's another one that comes up a lot, especially if you've got one heir that's on the farm and one heir that's off the farm, is the goal is you want to equitably or fairly divide that farm. And so this, again, was a story in my own family. My dad, went only to 2 years of college, came right home, worked on the farm and ranch to keep it going, whereas his brother went to college, left, and never came home. And so when it was time for my grandma to come up with her estate plan, she had decisions to make. Okay. Was her goal to divide everything equally between the kids? She could have done that, and that would look one way. Her goal was she wanted to fairly divide it. Her theory was my dad had been there, he had kept it going, he had built it. And so she did something very different than half and half, because to her, her goal was to equitably divide that. So again, I'm not saying one's right or wrong. I'm just saying they're different goals with a different approach. Don't lose everything we've worked for to taxes. We're going to talk about taxes here in a minute, but that is a hugely important issue to a lot of people. Ensure that mom and dad can qualify for Medicaid. So Medicaid is the, medical care, funniest, I guess it is insurance. I guess it's insurance for people that, asset-wise qualify. So lower income or lower asset folks can qualify for Medicaid. And so sometimes it may be that in order to pay for in-home care or nursing home care or whatever type of care mom or dad might need, if you don't want to pay out of pocket or you don't have liquid assets, sometimes what they'll do is they'll do Medicaid planning where they get assets out of mom and dad's name so that they can qualify for Medicaid. Okay. We could have a whole 2-day lecture just on that topic. Very complex. Okay. Before you do anything on that front, I would highly advise talk to an attorney. Medicaid planning is very tricky. There's some things you need to be really careful about. There's a 5-year look back window, so you can't make a transfer, the day before dad needs to go in the nursing home. Okay. So lots to think about there. We do have a podcast episode on elder law. I think it's very practical, very useful. It talks about those exact issues. All right. Okay, let's talk a little bit about taxes. Like we said, for some folks, the goal is really to avoid taxes. The estate tax is what most people worry about. And so again, this is a federal level tax, applies in every state. All right. Some states, I do not believe Oklahoma or Louisiana are included, but some states have something called an inheritance tax, where the tax is owed by the person inheriting the assets. We don't have that in Texas. Okay. Some states may. I think it's a limited number, like 8 or 9. Okay. What we're going to talk about is that federal level estate tax. Okay. And this is a tax imposed by the federal government, so the IRS, on assets that you transfer at death. They tax you on those transferred assets. All right. The way that this is set up is you get what's called a lifetime exemption. And you're able to pass the amount of assets allowed for in that exemption without paying any estate tax. Okay. For 2024, the exemption amount is $13.61 million per person. If you do the math, that's $27.22 million per couple. All right. Unfortunately for me, this is not a problem with my estate. Okay. I'm well under being worth $13.61 million. Okay. Most farm and ranch families, this isn't an issue for at that level. Okay. It's based on the current market value of your assets, which we talked about earlier. You kind of need to know what is that current market value of the assets. And here's why this is such a kicker. If you're over the exemption, you pay a 40% tax, 40. All right. That would kill most operations to have to try and come up with that money. And so here's what I'll tell you. If you are even close, and by close, I mean within a couple $1 million. If you're even close, you need to meet with an attorney and an accountant tomorrow, because there's lots of planning techniques that can be used in order to avoid estate tax liability. But the kicker is you have to do it before this is a problem. Okay, and it becomes a problem when you die. Okay, when you're looking at the value of the state, it does not include mortgages or debts or property you leave to charity. Okay, and also the tax is not owed on property left to a surviving spouse. Okay, and that is let me put this up. That's something that sounds better than it is. So what that means is, let's say the first spouse dies and leaves everything to the second spouse. No estate tax there. Spouse to spouse, no tax. But now the second spouse has the entire value of the estate, right? So that entire estate value is the value of the estate that's going to be passed when that second spouse dies. And that's where you can kind of get bit. Okay. There is something called portability between spouses. What that does is, if the first spouse dies and they don't use all of their exemption, they can give the leftover part of the exemption to the surviving spouse. Okay, so if let's say you had 10 million left on your exemption, you could port that to your spouse, and now instead of having 13 million, they could have 23 million when they die. So that can be useful as well. Okay. I always tell people this is as permanent as Congress. So Congress could change this tomorrow. But for now, this is the rule. It will change in 2026 if Congress doesn't act. So in 2026, that exemption amount is going to drop to 5 million per person. When they adjust it for inflation, it's going to be more like 7 million. Okay. But in 2026, your exemption is essentially going to get cut in half. Again, Congress could do something to change that, but for now, that's what will happen. So just be aware of that. Okay. That's the federal estate tax. Let's talk next about capital gains taxes. I promise this is the last of the tax talk. Okay. Capital gains taxes come up when a person sells an asset that has appreciated or increased in value over time. And this happens on any assets, whether it's land or a baseball card or stocks. Okay. If you have an asset that you bought at one amount, it's increased in value. When you sell it, you pay taxes on that increase. That's the capital gain. Okay. Tax rates range from 0 to 20% for long-term assets, depending on what you're dealing with. And then for short-term assets, the rate corresponds with the income tax bracket. So if you buy an asset and you sell it within a year, you're going to just pay income tax rates. If you held it for longer than a year, then those rates are going to be somewhere from 0 to 20%. Okay. We don't have time to talk about this. I just want to flag the issue for you. There's something called a 1031 exchange. I'm going to have a podcast episode on this in the next couple of months. But it's a way that lets you basically delay paying your capital gains taxes if you invest the money from the sale of land or property into another type of land or property. So again, we're not going to go into the details. Just know that's an example. If you face capital gains taxes, you might look at whether a 1031 exchange might be an option. Okay. A big issue here deals with, for agriculture, is something called the step up in basis, okay? And basically what that is, it's the adjustment of the value of an appreciated asset for tax purposes when it's inherited, okay? Let me explain. When my grandma bought our farm I told you about, she paid $50 an acre, okay? For simplicity of math purposes, let's say now that our farm is worth $850 an acre. If we sold the farm today, we would pay capital gains taxes on $800, right? $850 minus $50, $800. But my grandma died in 2004. If at her death, she left the land to my dad, right? So she did it by a will, or a transfer on death deed, or put it in a trust. If that transfer was made at death, we get what's called a stepped up basis. And so instead of that $50 cost basis that she paid, we could step that up to the amount it was worth when she died. So let's say it was worth $500 when she died. It's $850 now. If we sell the land, we're going to pay capital gains taxes on $350, right? $850 minus $500. But that's a lot less than the $800 it would have been without that step-up basis. Okay? So that's really important, again, especially for multi-generational ag operations. Huge deal. Okay? That stepped up in basis you generally get, again, if the asset is passed at death. So if my grandma, instead of leaving it to my dad in her will, if my grandma had deeded that over to my dad while she was alive, right? We'll get it out of her name, deed it over to my dad while she's living. You do not get the stepped up basis. All right. So again, that's where you have to think about what are our goals, because that may really drive when we want to transfer property. Okay. One last thing on capital gains taxes, then I'll see if we have questions. Capital gains taxes are only imposed when property is sold. Okay. So like, for example, my family bought that farm in the 50s. We still own it. We've never paid capital gains taxes because we still own it. You pay capital gains when you sell the asset. Okay. All right, Jacqueline, any questions on step 2?
No questions on that, but I did have a question in terms of if we could get the slide deck after all of this.
Yes, absolutely. I'll tell you what I'll do. I will email a PDF of the slide deck to Jacqueline and she can send it out to everybody who registered.
Perfect. Thank you.
Yep. Okay, easy enough. All right. Step 3, and this one I really just have one slide on. A lot of this, again, is thinking about the idea of business succession, because when we talk about estate planning, we think a lot about who's going to own the asset, right? Who are we going to leave the land to? Who are we going to leave the money to? Who are we going to leave the cows to? We also need to think about it from a business succession perspective of who is going to operate this farm or ranch, and how do we make sure they're prepared to do that? Okay. And if you look at the data on the transfer of small businesses from one generation to the next, this data tells us that only about 30% survive that first transition from one generation to the next. By the time you get to transferring from the third generation to the fourth, it's only about 3 or 4% that survive. Okay. So not having a plan here is not a good option. That is how farms and ranches die, is because we do not plan for who is going to succeed in that operation. Okay. So how do we ensure that operation continues? Right? We need to really think about this. We've talked about this a lot at my house. My dad has managed that farm since he was 14 years old, right? What happens when my dad can't do that anymore? How are we going to make that work? Are we going to need to lease something out? Are we going to need to sell something? Do we need to change our production practices? Is somebody moving home? You got to think through all of those things. So figure out who's going to be involved. And there's lots of different aspects of involvement, right? I mean, there's the day-to-day, right? The guy who's sitting in the tractor seat or caking the cows. There might be somebody whose involvement is strictly, financial management. Maybe there's somebody in the family who's really good at that and they can do the books, but they can't drive the tractor, right? Maybe somebody's really good at marketing. Maybe somebody is really good at paperwork, whatever it might be. Think about who is going to need to be involved, and then how new roles are going to be created or existing roles are going to have to change, right? As we think through that, really important to think about what type of training, education, and experience does the next generation need? And we need it now, right? Don't wait until it's too late to get them that training. So whether that's, you coming home and helping with something, or that's getting people involved in extension programs now, right? Like, let's bring our kids to the meeting too, whatever that might look like. A couple of stories here for us. One thing that we've done is I'm now involved with all of the stuff at the FSA and the NRCS office, right? Again, my dad took that over at 14. We figured out about 10 years ago, no one knew anything about that stuff because my dad just did it. And so now I'm involved. We talk about, why are you doing this? Why did you sign up for that? How does this program work? To where one day when I'm the one making the decisions, I've had the benefit of my own experience and my dad's knowledge, right? Another thing I had my dad do, and he kind of made fun of me, but I made him get a notebook. And I said, I want you to write every month, jot down what you typically do, right? When do you typically, prep the ground for planting? When do you order the seed? When do you plant? When do you wean calves? All these things that frankly, I used to know when I lived there, but I haven't lived there for 20 years. So we now have this notebook of all the things he does, right? Things like make sure you order ear tags before we start lambing. I wouldn't have thought of that, right? So that's something else I think you can do that can be really helpful. And then, like I say, start training and teaching now. Don't wait, because all of that knowledge and all of that experience that the older generation has will be gone one day. We need to start passing that on now if we want this operation to succeed. Okay. The last thing I'll say here, and again, we can have a whole class on this. You might want to think about whether using a business entity might be helpful from a succession planning perspective. And so what I mean by that, there are things like LLCs and limited partnerships, stuff like that, that might really be helpful to help you figure out how to transition the ownership, how to transition management, how to what we're going to do if somebody wants to leave or be bought out or there's a divorce. But there's lots of things that using a business entity can help with in this planning. So I've got a couple of podcast episodes on that. One of them is a podcast just on basic business entities. What are they? How are they used? What are the pros and cons? How are they set up? Okay, that's a podcast episode I've got. I've also got one specifically talking about using entities in estate and succession planning and how those can be used as tools. So again, y'all can listen to those for free. They're available. Okay. All right, that's step 3. Any questions on step 3? I'm going to guess not.
None so far.
Okay, perfect. So let's move to step 4. This is really why y'all thought you were coming. Okay. This is finally, what are the documents I need to have for my estate plan? Okay. Here we go. The first one, everyone needs to have these 4 documents. Okay. Every adult ought to have these 4 documents. Okay. It doesn't matter if you own agricultural land or not. So let's march through these. The same is true. Everybody needs these same documents. If you're out of state, some of the details may differ, like what you have to do to execute them and where to find forms. But the explanation of the documents and the fact that you need them doesn't change. Okay. Everybody ought to have a will. Okay. Even if some people will always say, well, we have everything in a trust, or we've done everything with transfer on death designations. Still have a will. If you have just a super simple will that says everything goes to the trust or everything goes to my spouse, right? Something that simple would avoid intestacy statutes. And what happens sometimes is, what if you forgot to transfer something into the trust? What if you forgot about this piece of land you inherited from grandma or these mineral rights from Uncle Sam, right? Whatever it is, make sure if you don't have it in that trust for whatever reason, that will take care of it and you're not in the intestacy statutes. Okay. Everybody's pretty familiar. A will is just a document that tells how your property is going to be distributed at death. So that's pretty straightforward. I will tell you this. In just a minute, I'm going to give you 3 documents you can do for free with forms online. A will is not one of them. So I really do not recommend using, I know you can go on lawyer.com and come up with a will for $39.99. Don't do that. Okay. Let me tell you, You'd be shocked at the number of problems with those wills. Just generally speaking, it's supposed to comply with Texas law, but it doesn't for some reason. The other thing is those forms are designed for like the average American who has a house in town, a car, and a savings account. They are not designed for an ag operation, okay? By virtue of owning land and being involved in agriculture, your estate is automatically complicated, okay? A fill-in-the-blank form for a will is not going to work for you, all right? So this really is somewhere I would recommend use an attorney. I know it's a cost up front. I promise it will save you money in the long run. Use a lawyer to get that drafted up, okay? Now, this is important. Do keep in mind that some assets are passed by contract outside of the will. Here's what I mean. There are some assets, it doesn't matter what your will says, they're passed by contract. So, for example, life insurance policies, you designate a beneficiary, regardless of what the will says, that beneficiary governs, and that's how it's paid. Okay? 401ks, typically, you designate a beneficiary. If you have a transfer on death account or a joint account with rights of survivorship, those pass outside the will. Okay? Critically important to make sure those beneficiaries are up to date. Let me tell you a story. There was a case that came out of the Dallas or Fort Worth Court of Appeals. It's been several years now. There was a guy who was in his 30s, single, went to work at the post office. As part of his benefits, he got a $350,000 life insurance policy. He names his girlfriend as the beneficiary. Y'all can see where this is going to go, right? So girlfriend is the beneficiary. They have a nasty breakup. This guy marries someone else shortly thereafter. They have 3 kids, house, mortgage, all the things. He dies 10 years later. Will leaves everything to his wife. She contacts the insurance company to collect the $350,000 and they say, no, ma'am, you're not the beneficiary. And she says, well, who is? And it's the ex-girlfriend. Okay. And the fact that the will said everything went to the wife didn't change that. It passed by that designation and the ex-wife or ex-girlfriend kept the money. Okay. So make sure you keep those beneficiaries up to date. Okay. Under Texas law, your will can either be handwritten or typed. It cannot be verbal. You can't tell someone. Okay. If you're going to do a handwritten will, the whole thing has to be completely in your handwriting. Can't have anything typed on there. Completely in your handwriting and signed. Okay? If you're going to do a typewritten will, has to be typed up and 2 witnesses have to see you sign it. They don't have to know the contents. They just have to see you sign. Okay? Obviously, if I'm telling you to go to a lawyer, I recommend a typewritten will. All right? The one place I would let you have an excuse to do a handwritten will is if you're like, oh no, I have nothing in place. What if I get hit by a bus on the way to the lawyer's office? Handwrite a will, right? Here's the date. Will of Tiffany. I leave everything to my husband. Signed. Stick that in your gun safe. And then as soon as you get the goodwill from the lawyer, you can destroy that one, right? But you'd have something to protect you until that point. Okay, in your will, and a lawyer will help walk you through this, but there's something called a self-proving affidavit. What that is, it's an affidavit that you would sign before a notary that just says, I, Tiffany, am the one who made this will. If you've got a self-proving affidavit, you can introduce that piece of paper in court instead of having to make your 2 witnesses to the will come down and testify. Okay. Another thing to consider in your will is an independent administration clause. There could be a scenario if you've got a real complicated or real contentious situation, you might not want this. But generally speaking, this lets the person you appoint as your executor manage the estate without having to get approval from the court to do everything. So it just gives them more freedom in executing their duties, right? And that is something in a will you're going to designate who is going to be the executor of the will. In other words, who's going to act on behalf of the estate when you die. I always tell people, think really carefully about that. Talk to the person, make sure that they're willing to do it. Becoming an executor of an estate is not like winning the lottery, right? Truthfully, it's more like winning a headache. So that's something to keep in mind as well. It's important to revise and update your will. So keep that in mind when you do a will and you think, okay, you can mark that off the list. Nobody likes marking things off a list more than me, okay? But you need to revise and update that will if somebody gets married or children are born, someone dies, there's a divorce, you purchase new assets, things like that. So just make sure you keep it up to date, okay? That's the will. Second document everybody ought to have is called an advanced healthcare directive. What this is, it's an instruction to a physician of what they should do with regard to artificial life-sustaining procedures if you are diagnosed as terminal or irreversible. So do y'all remember, I don't know, it's probably been 20 years ago now, the Terry Schiavo case in Florida? It was a woman who was on life support. Her husband wanted to take her off. Her parents wanted to keep her on. It turned into a whole lawsuit. They had to go to court and a judge had to decide. This form is an attempt to avoid that situation, okay? It's got to be signed before 2 witnesses or a notary. You can choose either one. It's effective when you're diagnosed. I think 2 doctors have to sign off that you are terminal or irreversible. And what you're telling them is just whether or not you want artificial life-sustaining procedures. Okay? You want to make sure that, doctors and lawyers and agents that you appoint for healthcare decisions have a copy of this. Okay? And then a statutory sample can be found online. Here's a free form. So in the Texas statutes, there's actually a fill-in-the-blank form for the Advanced Healthcare Directive. Print it off, fill in the blank, sign it or get it notarized, okay? And you're good to go, okay? This really is a helpful document for your family in the event that they do have to make this decision. This makes clear what your wishes were and can really give them some kind of solace in having to make a really difficult decision. So the other thing is, if you're going to do this document, discuss it with your family. Make sure that they do know what your wishes are. Again, just to avoid, it doesn't avoid all of, but to minimize the heartache as best you can in that situation. Okay. Next up is a medical power of attorney. What this does is it lets the person choose an agent to make medical decisions on their behalf in the event that they're incapacitated. Okay. Again, this one can be notarized or signed by 2 witnesses. It's effective when the doctor says you are unable to make decisions. Okay. So for example, I had to have a surgery a couple of years ago. I'm obviously asleep on the table. They get in there. There's a problem. A decision had to be made. My husband was my medical power of attorney. He made the decision. Okay. Once I woke up again, I'm back in charge of those decisions, right? Because I'm not incapacitated. So that's kind of how that works. Again, we have a statutory form available online. It's pretty simple, fill in the blank. Okay. This one's really important. And I've had people say to me, well, if I didn't have that, wouldn't my doctor just ask my husband anyway? Depends on the hospital. They might not, but I'll tell you where this really becomes important. Okay. Let's say that you're incapacitated for a substantial period of time, right? Maybe you're unconscious for a month. Okay. At some point, that hospital is going to need legal authority for someone to be making decisions. And if you don't have this free power of attorney form, the alternative is you can go get a guardian appointed. The appointment of a guardian is going to take forever, going to be in court. It's going to cost, at a very minimum, I'm going to say $5,000. I'm going to guess it's closer to 10. Okay. Or you can have a free fill in the blank form. All right. So that's the medical power of attorney. Last of our 4 forms that are documents that everybody needs is a durable power of attorney. This is the same idea. You're going to appoint somebody to make decisions for you, but not medical decisions. This is going to be decisions about property, assets, finances, things like that. Okay. Again, we're going to have a fill in the blank form here in Texas. You can select powers and include any limits. So if there are certain things you want them to be able to do and not do, you can do that. This form has to be notarized. No witnesses here. You have to have a notary. Okay. And it ends at your death or the appointment of a guardian. So that's important to understand. When somebody dies, the power of attorney doesn't work anymore. At that point, you've got to wait until there's an executor appointed and letters testamentary are issued so that they can act on behalf of the estate. Okay. On the durable power of attorney form, you can choose, does this power become effective now when I sign it? Or does it become effective only when I become incapacitated? You can choose what you want there. Okay. So that's the durable power of attorney. Jacqueline, any questions on our 4 documents?
No, ma'am, you're good.
We got a quiet bunch. Either I'm doing a really good job or I'm boring, one or the other. Okay. I also want to just mention a couple of documents that you may need. So those last 4 I told you everybody needs. Okay. These 3 you might need depending on your circumstance. One of them is a trust. And so I'm going to make sure to go in and we'll talk a little bit about trust, just the basics here in a minute. We've got a podcast episode on trust that's available. Another is called an out-of-hospital DNR. So that's a do not resuscitate order for someone who's not in a hospital or a nursing home. Everybody doesn't need that, right? I don't need that. If I get conked in the head, I need somebody to get to work saving me. Hey, I got things to do and kids to raise. I just had a good friend pass away who had been on hospice. She needed an out-of-hospital DNR, right? There's a form for those in the statutes. A doctor has to sign off on that with you. And an important thing to know about that is you need to make sure that that is somewhere readily available, right? If something happens and EMTs get called, they have a duty to act if they don't have that form in their hand. And so you don't want to be rifling around for it. I've seen people, again, on hospice who've taken it to the front door, right? So be aware of that. The last thing is you need to make sure you've got a document that provides for care of a dependent, whether that is a minor child or if you've got an adult with special needs. You need a document that provides for their care and to manage finances on their behalf. That may be included in your will, or it may be a completely separate document, but just make sure that that's addressed as well. Okay. Let's talk just briefly on trusts. Okay. There are different types of trust. So one category is it depends on when it's created. So some trusts are created while you're alive. Those are called inter vivos trusts. So I could go down tomorrow and set up a trust while I'm living, and I could operate out of it right now. Or I could do what's called a testamentary trust. That's a trust that gets created at your death. So in my will, I have it set up. If my husband and I both die, a trust is created for our kids. That would be a testamentary trust. Okay. The other question on trust is whether it's revocable or irrevocable. A revocable trust means just that, right? You can revoke it, change it, do away with it at any time. An irrevocable trust, it's much more difficult to make substantive changes to or to get rid of altogether. Okay. And it really matters depending on what you're using the trust for. Some protections you only get in an irrevocable trust. For example, from a estate tax planning perspective, you can use a trust to help avoid estate tax liability, but it only works if it's irrevocable. Okay. So again, lots here. I would definitely talk to a lawyer about setting up a trust if that's something you're interested in. They can help you figure out the right type that you might need. All right. What is a trust? Maybe I should have started there. A trust is basically just an entity that you create. Okay. And one person sets it up. It's called a settlor, right? That's the person that creates the trust to benefit another person. Okay. And then you appoint someone to manage it. I think minor kids are the easiest example to foresee. If my husband and I both die, all of our assets go into a trust. Okay. That trust is for the benefit of my minor children. All of the income, the money, anything there is to benefit my kids. But clearly my 8-year-old can't manage a trust, right? So we've appointed my dad to be the trustee. My dad would make all the decisions, investment decisions. Should we sell something or buy something? Can we make a distribution for them to buy a new car? Whatever it is, my dad makes the decisions about the assets to benefit the kids. Okay, that's how a trust basically works. That trustee has to manage those assets according to the settlor's instructions. And then they also have legal and fiduciary duties. So you can set the trust up kind of however you want. You know, some people will set up a trust that says the kids can have the money when they turn 18. I personally think that's a terrible idea because I think 18-year-olds are idiots. I was an idiot when I was 18. So some people will say they can have the money when they're 25 or when they're 30 or whatever it is. You can spell all of that out. Most trusts are set up to end when the duties are complete or the settlor's instructions direct for it to be closed and distributed. Again, very specific on the trust. Okay. I think there are pros and cons to using a trust, and it really depends on your situation. Again, I don't think everybody needs one. And I think that there are some lawyers, typically the ones older than me, that will say things like everybody should have a inter vivos living trust. I just don't know that that's accurate. So I want to talk about pros and cons, right? Because again, I think there are places you really need them. I just don't think it's a blanket prescription. So what are the benefits of a trust? It can provide for and protect the beneficiary, right? Like we talked about, minor children, they need someone to provide for, protect them, make those decisions. Same thing if you've got an heir that just flat out makes bad decisions, right? When somebody in my life dies, they have a kid that they just don't trust. And so I'm going to be the beneficiary of a trust to manage that on behalf, for this heir of theirs. It can allow for flexible asset distribution. You can write that trust up however you want, right? You can write that trust up to, let them distribute assets as they see fit, or it can be real specific. You can make up how the trust is going to be governed. Trust will allow you to avoid probate. Assets in trust don't go through the probate process. They just automatically pass when someone dies because they're in the trust. They can be used to avoid ancillary probate. So ancillary probate comes up if you own land in multiple states. Maybe good to have those out-of-state assets in a trust because that avoids probate in multiple states. So that could be important. And on avoiding the probate process, how much that matters depends on the state you live in and how onerous that process is. In Texas, it's not a terrible process. And so sometimes you can spend more money trying to avoid probate than just probating something. That's not true in California. In California, everybody probably needs a trust. I've been told that in Oklahoma, the probate process is more difficult. So you may want to look more seriously at a trust if you're in Oklahoma, for example. Again, an irrevocable trust can be used to help avoid estate tax liability. Trusts allow for privacy, again, because you don't file anything in probate, so there's nothing that's public record. An irrevocable trust can potentially avoid creditor issues. So if you leave the ranch to an heir and that heir gets sued, and property in an irrevocable trust, creditors can't get to, okay? It can allow for professional management of property. So there are trust companies that manage the ranch for people, right? They handle all the leases. They take care of all the documentation and paperwork and things like that. So that can be a plus side of a trust. What are the downsides? It's almost certainly going to be an added expense, right? There's going to be costs to set the trust up, maybe costs to manage the trust, costs and expenses of the trustee, things like that. It's an added hassle, right? There's more things to do here, more moving pieces. There just is more hassle to it. You have to take steps for the trust to be effective. This happens sometimes where people will spend all of this money and hire a lawyer to set up a trust, but then they don't ever go actually put the assets into it. So like if I create a trust and I want my ranch to be in the trust, I would have to deed the ranch to the trust. I don't own it anymore. The trust owns it. If you don't take the steps to put those assets into the trust, it's just a piece of paper. Okay. There can be potential tax consequences here. I'm not an accountant, but I would talk to one about any tax implications. People may not understand the rules. Sometimes, especially if people go to a lawyer and they say, oh, well, everybody needs a trust, we'll just draft this up for you. Sometimes people don't understand what that trust does, how it works, what it means. So if you're going to do this, make really careful that you really understand how all this operates. And then the last thing, in order to get certain protections, it may have to be an irrevocable trust, right? And of course, that means it's irrevocable and you can't make changes. Okay. So that's step 4. We'll go to step 5. This one's pretty quick, and then we'll take any questions on anything that we've covered.
Hey,
Step
Tiffany,
5
we
is
do
just-
have 2 questions in the chat.
Okay, go ahead.
How does it work when a husband and wife both have a Texas partition and exchange agreement in place, but no will?
So true lawyer form, I'm going to tell you, it probably depends on that partition and exchange agreement, exactly how that is worded. It also probably depends on exactly how that property is deeded. So a partition and exchange agreement, unless it has like testamentary language in there, or unless there's something in the deed that includes some sort of like testamentary intent, that agreement alone may not be enough to get rid of the will. That's where you need a lawyer to help you look at that and see, like, do I need something else in place, like a will or like a transfer on death deed or a ladybird deed or something, to make sure that that testamentary aspect is taken care of. But without seeing the document, which obviously I'm not allowed to do, without seeing that, I just can't tell you for sure. But I would sure check to make sure there's testamentary intent there.
Then another one, if I typed my own will, went to the bank, got it notarized, and had 2 witnesses sign, do I still need a self-proving affidavit?
Great question. You did that exactly right. You actually did belt and suspenders, because you got 2 witnesses and a notary on the will. The self-proving affidavit, you do not have to have that for it to be valid at all. If you do have it, it's just another option to offer that in court. So I always tell people it's handy, certainly not necessary at all for that to be a valid will. Since you've already done it, you got it taken care of, you have a valid will, I wouldn't lose sleep over that self-proving affidavit.
Okay, and then the last one is a trust question. How about wanting to keep land in the family? It can be used for more than agriculture, but can never be sold. Is that reasonable?
Yeah, well, look, reasonableness is not something that I can speak to. Is it legal? Yes, right? So I don't know whether that's the right decision for anybody, but yeah, you definitely can set that up. You could set up a trust like that where the land has to stay in the family. There are different things you can do. You got to be careful. There are certain things where you have to watch restraints on alienation. Like there may be some limitations there, but generally speaking, yes, you can set those types of limitations either within a trust or within something like an LLC.
And that's all we've got right now.
Okay, good questions. Keep them coming. I like those. Okay, step 5 is just drafting and implementing the plan. So once you've kind of done all this homework and you've got your flight plan and you've thought about your goals and you've thought about who's going to do things, right? That's when you need to use a team to help get this all done. So I recommend work with an attorney, an accountant, banker, family members, get the team put together and get this all kind of organized. You know, in a perfect world, especially that attorney and the accountant work together on this because they both have expertise, and that's, you know, the best case scenario is that they're working together. And then you need to continue to evaluate and revise. You know, we talked about this on the will, but your entire estate plan, you know, you can't just do it and be done forever. You need to keep talking through the plan with your family, make sure that there aren't changes. that you need to make sure, again, you know, kind of the big events in life that come up, death, divorce, birth, purchase and sell a property, things like that. I think it's also really important to have a set time when you're going to review these things. I do this once a year, so I'm not kidding you. On New Year's Day, I go to the gun safe, I pull out the flight plan, and I just flip through everything, right? I check the will, the documents, the beneficiary designations, and just make sure nothing has changed. If it has, I can catch it and we can update like we need to. Normally, we don't have to, but that once a year review, I think, is really important. I'm going to give you a whole list of some additional resources that are available. If y'all are interested in that, you can find them. Just a couple I'll mention. I did a video series for Texas corn producers, similar to this, a little bit longer. I think it was about 3 hours. That's available for you to watch for free. Jacqueline's going to post this video on YouTube as well, so we'll add it to the list in case you've got family members that need to watch this, or you might need to see it again. Ohio State, if you Google this, Ohio State has a really great publication called Getting Your Farm and Family Affairs in Order. It's like a little workbook. I think it's maybe 20 pages to gather up all that flight plan information. Names of your kids, what's their birthday, what's their social security number, list out your assets, things like that. So that's a really handy little worksheet. Oklahoma State has a really great handbook. It's called Farm Transitions. It's about 200 pages worth of information on farm and ranch, estate and succession planning. So that's available as well. Okay. One thing that I haven't hit on, let me just say this and then we'll close out and take questions. I really caution people, there is not a right or wrong way to do this, okay? I am very careful not to tell you what you should or shouldn't do as far as figuring out how to leave the land that's best for you and for your family. You do what you want, okay? I would caution you against leaving the land jointly owned by multiple heirs, okay? And I know that this is a popular thing to do, right? Where you say, well, we've got 4 kids, we're going to make them all joint owners. That can come with some real problems, all right? And so what I would tell you to consider there is that something that's going to be workable? Would you be better off to divide it into 4 pieces and each one of them owns 100% of their piece, than each one of them owning a quarter of the whole? Okay. One big concern when it comes to joint ownership like that is the legal remedy of partition. So what that means, let's say we've got 4 kids that are joint owners in the farm. Any one of them has the right to seek partition, which means to force it to be divided up. Okay, if it can be divided up equally, it will be so divided and everybody will get their own piece, right? If it can't be divided up equally, which is frequently the case with land, right, and ag operations, that can be pretty complicated. Then what can happen is that they can force a court-ordered sale and the property is sold and the other heirs have to try to buy their part back, right? So because of that threat of partition, I really caution against joint ownership of land. Like I say, I think better off to divvy it up and everybody gets their piece. If they need to have something where everybody's working together, an LLC can be a great way to do that, right? You have an operating agreement that sets exactly out how this is going to work, what's going to happen. What if somebody dies? What if somebody wants to sell? What if somebody just wants to leave, right? So that's one thing I didn't mention earlier that I want to make sure I get out. Okay. The last slide from me, I think when we get through with this presentation, a lot of times everybody's head is spinning, right? I threw a bunch of information at you in a hurry. I talked too fast. I know all of these things, right? I want you to think to yourself though, about why it's worth going through the hassle. All right. And for my family, here's the answer. Okay. You look at that picture there in the middle. That's me and my dad and my little boy in front of a ditch. My dad, we still have got some places where we irrigate with siphon tubes out of a ditch. Okay. My dad taught me to set tubes in that same field. And then a couple summers ago, he taught my little boy to do the same thing. And I'll tell you what, if I can manage to make sure that that can continue, it's worth a whole lot of hassle for me to do these steps that we talked about. Okay, so that's kind of my pep talk to you. And then here, this is my contact information. So like I said, I will send the slides to Jacqueline. She'll have those. If y'all have questions, if you need information, if you can't find those forms that we talked about, please feel free to reach out to me. I'm sure more than happy to help. You'll see there I've got social media as well. On that note, on Facebook right now, we're doing a giveaway where you could potentially win a 2-night stay and wine tasting in Johnson City. So if you're interested in entering for that, go check out our Facebook page. It's just called Texas Agriculture Law. Okay, so with that, we can open it up to questions. We've got about 30 minutes left. I mean, we intentionally did that to make sure we got questions answered. Given that much time, I will take questions on estate planning, or I'm willing to field questions on any ag law topic you might have. So if you want, you can put those in the chat box, or Jacqueline, if it's okay with you, I'm fine if people want to unmute and ask their question as well.
Either way will be fine.
So we'll give everybody just a couple of minutes here. If you've got questions, unmute yourself or type them in the chat box.
Where can they listen to the podcasts that you mentioned, Tiffany?
Yeah, sure. It's just at this aglaw.libsyn.com. Let me see. I think I can pull it up right here. Give me 1 second. I'll try to put it over here. There we go. So if you just go to the address there is aglaw.libsyn.com. I'm going to put it in the chat right here. So there's the link, and this is what you'll see. All right, it's just this list of topics. So if you wanted to listen to us talk about the Corporate Transparency Act, you push play. Oh, here's an estate planning related one. Long-term care considerations for farm and ranch families. This was great. A discussion about, how do we decide if we can afford if somebody needs to go to the nursing home or not? You want to listen to it? You just click on this little arrow right here and it'll play right on your phone or your computer.
Tiffany, somebody asked if you're taking private clients.
I wish I could, but no. So Texas A&M won't let me do any private representation. They say it's a conflict of interest if I on the state's dime, go around and tell you need a will and then pass out my business card to make one, right? I am glad to recommend attorneys to you that do this kind of work in private practice. If you'll shoot me an email or give me a call, I'm happy to do that.
Also in the chat box, everyone, I did post a link to a survey. Part of mine and Tiffany's job with working with A&M is to report back to the state and our shareholders. And the easiest way to do that is through some survey data. So if y'all would take a few minutes and fill that out for us, it would be greatly appreciated.
And I'll put a link here to my blog as well. Give me 1 second. I'll pop that in here too. So the blog looks like this. I assume we can still see my screen.
Yes, ma'am, you're good.
The blog looks like this. And so on Monday, I did this article here about the new court order on dicamba. There's the pop-up box. I'm sorry. Okay. Here, weekly roundup is just I'll click on that. It's just a list of interesting articles in the news and a quick summary about them. So you guys have that. Here's an article right here. Is your farm business ready for your death? And then here's a link to read that article. So I'll put this in the show notes as well.
Tiffany, one question was asked, anything coming up about water laws?
So let's go look. I have a list of all my upcoming presentations that my saint of an assistant keeps up to date. I think she might be on here. Hi, Lucretia. I don't have anything specifically water law related, I don't think, until I speak in August at a conference. I definitely keep up to date with water law on the podcast. We've done several water law episodes, and then on the blog. In particular, I'll just tell you there's a case pending. It was decided by the El Paso Court of Appeals, It's currently pending at the Texas Supreme Court to see if they're going to hear it. And it's all about who owns produced water from oil and gas production. So, you know, like when they drill an oil well, they pump the oil out, there's water that comes out with it, right? And so the question has arisen, who owns that? Is it the oil company that produced it, or is it the landowner, right? Because in Texas, landowners own the groundwater, surface owners own the groundwater. Huge issue. The Court of Appeals said it was owned by the oil and gas company. There have been a number of groups, including groups like Texas and Southwestern Cattle Raisers, et cetera, that have said that they think it should be owned by the surface owner, right? Because again, surface owners typically own groundwater. The El Paso Court of Appeals said it wasn't groundwater, that it was oil and gas waste. Oil and gas waste. And it was owned by the oil and gas company. So I think that could have really huge implications for Texas landowners. It's something we're watching really close. We'll definitely let you know if the court comes out on that. That's the big water thing that's going on. You know, waters in the United States, always a big issue that continues being a situation. So, anyway, I just, for the record, that's kind of what's going on with water law. I don't have any upcoming presentations immediately.
Just for everybody, in that survey, there is a question in there that asks about topics that y'all are needing or wanting more information on. If that is something, the water laws or any type of information along those lines with farming and ranching, please put it in there. Let me know, because my committee and I are working on planning our second annual Women in Ag Conference here in Fort Worth, which will be held in September. More information will be coming out about that later. But any topic that y'all are looking for kind of helps us with the planning. So please take your time and fill that out for us as well. Tiffany, another question. Does a dissolved LLC have any legal status?
So I think if it's truly been dissolved, right, and like all the requirements for wrapping it up in the operating agreement or as required by the Secretary of State have been handled, I don't believe it would still have legal status. Again, it has to truly have been wrapped up, though, not just, you know, they decided we're not going to use it anymore. So that could depend a little bit on the specific facts. On that note, that's something I should have mentioned. On that note, talking about entities like LLCs, corporations, limited partnerships, I want to make sure you guys see, I've got a blog post, that's why I'm scrolling. There's a new federal reporting requirement. If you are an owner or otherwise involved with any sort of entity, LLC, limited partnership, corporation, there's a new federal reporting requirement that you have to file. If you were created before 2024, you've got to file it this year with the U.S. Department of Treasury. It's called FinCEN, the Financial Crimes Enforcement Network. It's a new law. It's a new requirement that you've got to give information about your entity and all of the business beneficial owners. Pretty steep fines if you don't comply. So, including jail time and money. So I would encourage you, make sure you're talking again to a lawyer and an accountant if that might be an issue for you. It applies to all entities. There's not exceptions for like ag or small, or there's just one member. The reporting requirements still apply there. So I would just make sure you look into that. Any other questions? Making sure we haven't missed any in the box, but I think we got them all. Okay, Jacqueline, I don't see any more, so I think we got everybody covered.
So it would help if I unmute myself today. It's Friday. Thank you, everybody, for joining us today. Again, if you've got a few moments and look in that chat box for that link for that survey, that just helps Tiffany and I out as far as bringing programs such as this to you later on. Also, again, this meeting has been recorded. Give me a little time and I will get it posted on our YouTube page. Probably the first part of March. Our county shows us next week, and I'm going to be wrapped up, tied up with that this next week. But I will get that sent out to everybody, as well as the PDF of the presentation today. But if you've got any other questions, feel free to reach out. Actually, there is one more question, Tiffany. Can you go over the step-up basis if the land is deeded to an heir prior to death?
Yeah, sure. The simple answer is if the land is deeded to an heir prior to death, there is no stepped up basis. So let's go back to my example with my grandma. And this is what happened. My grandma bought the land in the 50s for $50 an acre. Okay. She died in 2014 when it was worth $500 an acre. Okay. And now it's worth $850. When she died, okay, she had already deeded it to my dad. So before she died, she deeded that land to my dad, which means when she died, we did not get the stepped up basis. So our basis now is still 50 instead of 500. Okay. Had she done that transfer at death, we would have gotten that stepped up basis to the $500. Okay. So what happens now? Well, right now our basis is 50. The value is 800. Let's say that when my dad dies, if he gives the land to me and my brother at his death, we'll get the stepped up basis to whatever the value is at that time. Okay. So we'll get the full step up from 50 to whatever over 800, right? If he does it at death, if my dad were to decide to deed it over to us today, there would still be no stepped up basis. Our basis would still be $50, right? Even if the value is now 1,000 an acre, for example. Okay. And again, that only matters when the asset is sold. So right now, it hasn't affected my family that we didn't get a stepped up in basis when my grandma died. But at some point in the future, should we look to sell any of that land, it would be a big whammy that we didn't get that stepped up basis because of the increase in value. Did that help? Oh, she says thank you. So hopefully it did.
Yeah.
Okay.
So when does a trust end?
Completely depends on how you structure the trust. Some trusts are for a set period of time. Some trusts are until a certain thing occurs. Some trusts are set up that, like when the kid turns 30, you'll dissolve it. Sometimes it's like until this business is completed. So it's up to you. You can set that up however you want.
Any other questions? Feel free to unmute yourself as well.
Looks like we got them all in the chat. So I think we're good there.
That works. So, well, again, thank you everyone for your time today. If you've got any other questions, I will be sure to send out my contact information and I can relay those on to Tiffany. Or you can contact her directly and I will be getting everything out to y'all as soon as possible with things. Tiffany, as always, thank you for your help today. Always great information. But everybody have a wonderful weekend.